Hey, is the judge here? I'd like to speak to him. I understand that, but I would like to. I came in and I dropped off an 8-page grievance that I served on the judge's chambers on February the 7th, detailing out violations of state law, and what I saw were violations of federal law. Certainly serious grievances that 2 days later, Communicare, what I've said in retaliation, set out to take out another affidavit for commitment on me. It's more than a coincidence that February 7th I turn in a grievance and I serve it on this chambers. And 2 days later, an affidavit for commitment's taken out, and I'm not even given so much as a hearing. Deprived of due process. I would like to speak to the judge about that, because I feel like my grievance was completely ignored. But the judge was able to entertain their affidavit, and I want to know why my grievance was overlooked. That's a simple, I think anybody would want to know that. I wouldn't have filed it and served it on this chambers if I didn't want it to be looked at. There's no excuse for it, Tina. None. I mean, I put a lot of thought into that 8-page letter that I came, and I made sure to bring it to the judge's attention. And I didn't even get a hearing. I mean, what part of due process being deprived is that not directly qualify as? I try to do things the proper way, and and my procedure gets completely ignored. And then I'm told I can't speak to the judge, but the judge entertained the affidavit from Communicare that's now created a whole heap of madness. Then I want to file something. I want a hearing in front of the judge. What do I need? I mean, this has already been adjudicated, but it needs to be addressed. There needs to be a hearing. I need to have a hearing in front of Judge Little. So what can I do at this point, now that it's already adjudicated, to get a hearing in front of Judge Little? But that's a problem. That's a major problem in itself, as far as the laws, the commitment laws in Mississippi. How does that afford fair due process to the other party? It doesn't. It doesn't give them any none. That means I could go and swear an affidavit on you if I wanted to, and then you get picked up, and it's not fair. For the other party that's on the receiving end of that to not even get a hearing, to not get heard, and to have gone through the steps that I went through to make sure that a proper 8-page response was filed, trying to get a hearing before the judge, and then 2 days later, another affidavit's taken out, and, I'm not even given a chance to even speak. I missed the birth of my only son because of this. He just got moved. He just got rushed to a Bonner because his lungs aren't developed. They're not developing. He came about because of the 12 deputies that came out to my yard to pick me up on that last affidavit. Somebody needs to be held accountable. There's over $1 million in hospital bills right now because of it. Right, you can't, but you're telling me that I have no recourse. I can't say a thing to the judge, and that's wrong. I don't care how you look at it, that's wrong. Because I was on the receiving end of it, you're darn right, yeah. But I also know the law. I know from a constitutional basis, I know that my liberty, I'm afforded liberty. The only way my liberty can be taken away is by due process of law. The only way. And to not be given a hearing, to not even be able to speak to the judge and show what's really truly going on here is a laughingstock. Judge, I think I have a right to speak to the judge, Tina. What can I file to get a hearing then? What if this was you? What if this happened to you? And you weren't given a hearing? And you were told the same things that you're telling me? How would that truly sit with you, Tina? I would love to know. How would that truly sit with you if you lost what I lost and you were told the same things you're telling me? What other way is there to see it? I was deprived of my liberty. It put my wife into preterm labor. I turned in an 8-page detailed complaint 2 days prior to the last retaliatory affidavit that was taken out by Communicare, saying that I was not compliant. But if you read the letter that I served on Ms. Chambers, it showed in broad detail that I didn't want to go back into the same lion's den and the same lion that maimed me until these issues were sorted out and addressed. I asked for a week's time for them to address the issues in the complaint. They didn't wait a week's time. 2 days later, they go and file an affidavit saying I'm not compliant with treatment, and that's bull. I never said I was not going to comply with treatment. I said, before I go back over there to y'all's property, before I walk right back into that same lion's den, I want these issues addressed because they're clear violations of the law. Y'all want to cite the law? Let's cite the law. In the Mississippi Code, I can show about 20 different places where the law was butchered and overlooked. No, it's in the Mississippi Code. I've got it highlighted. It was butchered everywhere. I mean, I want to file something. The case can be reopened. I know that I can reopen it with a filing. I'll file a motion for dismissal and expungement because I think both of those are in line because of what happened. I'll at least file a motion for dismissal and get that heard. I'll go type it up downstairs, and then you can let me know what the judge's availability on his calendar is. If it's no different than if I were to file a motion for dismissal on anything else that happened in Chancery Court. If it was a family matter, or if it was a commitment proceeding, if it was done with ill intent, if there were steps that were skipped that should have been followed, then it needs to be dismissed. It must be dismissed. No, my issue is with the court because the court was the one that signed off on the commitment. My issue is with Communicare. But this court also had a dual responsibility to look into what was filed because I made sure can't be said that it wasn't seen because I filed the 8-page letter and served it on Ms. Chambers. I would like that addressed. I would like to know why, anything that I say, anything that I swear on affidavit gets overlooked and not just a blind eye turn to it, but somebody else can put something on affidavit that's not even supported by witness, that's, full of conclusory judgmental terms, which it's barred from. I mean, the stuff that was put on the affidavit, Rachel Alcorn even admitted she had no knowledge of. It stemmed directly from the sheriff. The sheriff passed constitutionally protected activity for one, for two, lies onto an employee of Communicare to have me committed. Nobody's shown me one bit of proof where I've ever provoked anybody with my minor child, because that's a joke. I've never done it. But you just rolled your eyes at that, thinking that I guess that wasn't the case. I mean, not one person has shown me one bit of proof to the claims that were made. But apparently this county thinks it's all honky-dory to go ahead and commit somebody and not even give them the right to a hearing. And that's wrong. It's making me mad about a second. I'm going to type up a motion. I'll be back.